welcome to the Great Trials podcast. This is Steve Lowry with Yvonne Godfrey. Yvonne, how are you doing this Monday afternoon?
I'm good. I'm excited, Steve. I'm going to call it a crossover since we've done enough of them. I'm going to call it a crossover podcast. We've got GTP with DAP.
And with hidden legal figures. So we made this announcement last time that we had Derrick Alexander Pope on, who's been on the show a number of times and is one of our favorite guests. That I now think that Derrick has officially become we've had him on the show more than anybody else, including our law partner Jeff Harris. So, yes. So congratulations, Derrick. You are now the new champion.
Thank you, Steve. And as I told Jeff, I'm coming for you, and the throne is mine.
That's right. That's right.
What does he win, Steve?
We love to give away our mugs. I don't know that we've ever told our listeners that every guest who comes on to the show actually gets a mug, a Great Trials podcast mug. And so Derrick has basically a family set of mugs now. He's got everybody in the family can walk around with one. So we'll have to come up with something who's been on the show the most and find something special for Derrick.
Yeah. We'll think about it. In the meantime, we should bribe our, well, I shouldn't just say this while we're recording, but I'm going to anyway. We should bribe people to send us questions. You know, we've been trying to get listener questions with mugs. Yeah. Maybe we can send them a mug for a question.
Yeah.
Anyway,
it's got to be a good question. One that we use on the air. Yeah.
At our discretion.
Yeah. We send mugs out everywhere. No, which I'm happy to do. I love giving away our mugs because it usually means we've had a great show. So
yeah. Exactly.
Well, Derrick, how are you doing?
I'm doing good.
Well, it is good to have you on the show again. And for those listeners who don't remember Derrick, he's been on the show a number of times, always just a wealth of knowledge, especially when it comes to history, when it comes to civil rights. And, basically just giving us a great view of some of the huge legal cases of the past and talking about their effect on civil rights and how they've affected where we are now in the legal field. So welcome, Derrick.
Thank you, Steve. Thank you, Yvonne. It's always my pleasure to be on Great Trials podcast. Work that you guys do, uncovering the background, the insights of litigation, letting the listener know how these things actually take place. It's a monumental, tremendous work that you guys do, and to think enough of what we're doing at Hidden Legal Figures to have, as Yvonne said, that crossover to make the connection between the present, the past, where we would like to go, hope to go in the future. It's always a good conversation. Always appreciate being here.
Well, we love having you.
Yeah, and I want to mention for our law student listeners, I know we have some, and I really encourage you to check out all of our episodes with Derrick and to check out his podcast as well, because my experience in getting ready for the episodes with Derrick, and obviously when we're talking about them, is how much of this stuff I did not learn in con law 1 and con law 2. And, part of that is just, it's a lot of ground to cover in those classes. It's a lot of cases to cover. So you don't get to dig into the background in some of these cases like you get to on this show. So I encourage people to check out Derrick's podcast and check out our other episodes with Derrick if you haven't, because this is stuff I really wish I knew in law school. Stuff like how we're going to talk about today, like how these cases happen and kind of the strategy behind that is something that, I don't think I learned that much about. And if I did, I forgot it in law school.
Yeah, right. Exactly. It is really good to hear some of the backstory to some of these cases and then how one case leads to the next. And we're going to be doing that today with two cases. And I'll talk about them in a second. I'll tell you the names of them are Buchanan versus Worley, which is a 1917 Supreme Court case, and then Shelley versus Kramer, which is a 1948 Supreme Court case. And both cases have to do with property rights and either city ordinances or restrictive covenants that basically made it so that Black Americans could not live in or purchase property that was in predominantly white neighborhoods. And so we're going to talk about those. But Derrick, let me, I know we do this every time, but I want to make sure everybody knows who you are, what your background is, and where they can find you. So first I'll say that Derrick is the president and founder of the Arc of Justice Institute. You can look him up on onthearc.net. That's on the, and an arc is ARC. .net, so onthearc.net, and he is also the podcast host for Hidden Legal Figures podcast, which am I right, Derrick and Yvonne, that actually features Yvonne doing some voiceover work on there?
You are correct about that, Steve. When we began our second season, we want to go back to where a lot of these issues began, and they began in the Reconstruction period. And unlike the work we were doing in our first season, when we were fortunate enough to be able to find the audio recordings of some of the voices of the lawyers that we depicted in the podcast during the Reconstruction period, we don't have that luxury.
Right.
So we decided what we needed to do was to recruit some incredible voice talent. And Miss Yvonne Godfrey.
That's right. That's right.
Incredible voice talent.
Yeah.
Portrayed, among others, the 16th president of the United States of America, Abraham Lincoln.
Let's hear it, Yvonne. Let's hear your Abraham Lincoln.
Check out the episode. Check out the episode, Steve.
Yeah,
I can't believe you haven't heard it already.
Right, exactly. Probably when you had to, book Yvonne to do her voiceover, you had to talk to her manager, who talked to her agent, who then talked to the other agent, and then finally you get to Yvonne.
You cannot imagine the arduous measures we had to go through.
That's right.
but it was all worth it. And I know that when we finished, and each time I listen to them, I know that the very next phrase I'm going to hear is, and the Emmy goes to an outstanding podcast series.
That's right.
That's right. Please, Yvonne Godfrey. Yvonne could not be with us today because she's off. Right. She's doing some other, but we want to accept this award.
Right. That's right. That's right.
Oh, well, I can dream.
Well, Derrick, just to give a little bit about your background, before you were the president and founder and director of the Arc of Justice Institute, you have been the chief of staff of the Fulton County Board of Commissioners, the general counsel to the Medical Association of Georgia. You were an adjunct professor at Georgia State University Law School, assistant legal counsel to the Georgia General Assembly, and part of the White House Data-Driven Justice Initiative under President Obama, a graduate of Morris Brown College, and then Loyola University Law School. And then I wanted to make sure I mentioned these, that you wrote a book called By the Content of Our Character, a Declaration of Independence for Colored Folks, Negroes, Black People, and African Americans, and then did a spoken word CD called The Racetrack with your daughter, I understand. So very good. And then I think what we were talking about before this is you are getting ready to start a new adjunct professor adjunct professor job at Mercer University. Is that right?
Correct. That's right. That sure am. Class starts Thursday, as a matter of fact, and it'll be the legal environment of business. And so I'm looking forward to that. That's a little new wrinkle. I've, as you mentioned, taught at the law school level, and that was a bit familiar to me because, of course, having been in law school, I know exactly what the students are thinking. Practiced in the area. I have more than extensive experience and understanding of anything they might ask. But trying to distill this topic down to a group of undergraduate students,
right?
That's a little challenging, but I'm really looking forward to it. Kind of very excited about it. How to take a piece of information and make it relevant, make it timely, make it current, make it intriguing to them. And I was wondering what I could do, and I know there's going to be a generational difference, and I was wondering how could I make them familiar with it. And I was talking to my daughter that you mentioned, and of all the things that you did mention that I've done, that's been my favorite, the CD, the Racetrack CD, and it's my favorite because I got a chance to do it with her.
Right.
That was my favorite. But I was telling her about the class, and I told her that I want to find some way to have some kind of, an example that they could relate to, that no matter what the age group is. And I started saying that there's a company that what I know everybody understands it. As soon as I said it, my daughter said Disney. I'm like, yep, yeah, there it is.
Yeah.
So we're going to look at how Disney, how it started, how it formed, how it evolved. We'll take a look at some of the cases that they've been involved in, some intellectual property matters, and then we'll talk about the formation, the structures of business. What are the kinds of decisions you make when you're organizing your business? What are some of the common legal questions and issues that arise, irrespective of what kind of business you have, big, small, service, product, industry? What are these things that are common to it? And I think the room is going to be filled with some individuals who want to go on to law school, who are business majors, who may find themselves in upper level management or at some point being entrepreneurs. So it's going to be pretty interesting. I'm looking forward to it.
Yeah, it sounds interesting. And I mean, I think picking Disney as sort of a basis. I mean, they're involved in so many different areas of business, have done so much, and you know, you'll be able to talk about a lot of information there.
Yes. So that Disney was almost a no-brainer for just that reason.
Yeah. I mean, that's a great idea, because you really, if you're a lawyer, you still end up wanting to know, or, you know, you end up really working for a business and wanting, you know, there's the law that you practice, and then there's the law that affects your business. And then I'm sure we have all experienced this, you know, like getting texts from like the person who cuts your hair, or the person who, you know, the movers. I mean, these are all real examples of people that I've gotten that once they know you're a lawyer, things come up in their business where they want to know how the law is going to play in. And I frequently don't know the answer. But all of that to say, it comes up all the time. What a great idea for a class to kind of, you know, talk about that intersection and to have such a good illustration. I want to take that class.
Well, drop on by Thursday. We do it Tuesdays and Thursday for the next 8 weeks, starting this Thursday from 1 o'clock to 3:15. Nope, I'm wrong. 1:15 to 3:30.
Okay.
Right.
All right.
Over to the Atlanta campus of Mercer. And you know, the last time we were doing this, Yvonne, but that's how we got you on the podcast to portray Lincoln. So now that you mentioned your interest here, you might make a guest appearance in the class to offer some litigation strategies. So check your inbox. You might see.
Ready.
So as Walt Disney himself, or are we talking Mickey Mouse? What are we talking here?
Haven't figured out the character yet.
Right.
Give me some time, Steve. We'll come up with one. There's so many to pick from.
That's right.
I feel like I have kind of an Ursula look happening right now.
Okay.
All right. Anyway, I'm not anti playing a villain, but
right.
We'll see where it goes.
Okay.
Anyway.
All right. Well, let's talk about the cases that we that we have featured in the show today. And Derrick, I was planning on starting with Buchanan versus Worley, since that comes first in the in the timeline. It's a case that dates back to 1917. And what I thought was really interesting about this case is that it's a civil rights case that most people don't talk about, and it's well before Brown versus Board of Education, well before the 1964 Civil Rights Act. I mean, we're talking back to 1917 is when the decision was made, and I think the events that that make it up happened in 1910. So we're talking, I mean, basically 50 years before the Civil Rights Act. So just the basic facts were that the city of Louisville, Kentucky had an ordinance, a city ordinance that forbade any Black individuals to own or occupy buildings or to have a residence in areas that had essentially a majority of white persons in there. And there was basically, I mean, it was obviously a very race-based law, but also there was some claim that they thought it would somehow diminish the value of the properties. But essentially what happened is you had a local civil rights leader named William Worley, who was the head of the NAAC, I think, NAACP in Louisville. And then you had Charles Buchanan, who was a local real estate agent, and he was somewhat friendly to the NAACP and to Mr. Worley. And basically, he had a piece of property that was for sale in a predominantly white neighborhood. And so William Worley agreed to buy it. Or the price, I think, was $250. But he put a condition, if I'm getting this right, and tell me, Derrick, if I am, but he put a condition in his in agreeing to buy the property, and I'll just read what I have here. It says, "It is understood that I am purchasing the above property for the purpose of having erected thereon a house which I propose to make my residence, and it is a distinct part of this agreement that I shall not be required to accept a deed to the above property or to pay for said property unless I have the right under the laws of the state of Kentucky and the city of Louisville to occupy said property as a residence." So he put that condition in there, and obviously it was known that this was in a white majority neighborhood. And if I read the facts right, he did not pay the full $250. He paid $150 and withheld $100 because the property wasn't worth as much, since he would not be able to build his residence there, would not be able to live there under the city of Louisville ordinances. And I know Yvonne's going to get on there. I should have said it right. Louisville. I got it. It's Louisville.
Yeah.
All right. So I know I was screwing up the pronunciation as we were talking. But so anyways, so the city, so basically then Mr. Buchanan sues Mr. Worley to basically enforce this purchase agreement. And the case ends up going up to the Supreme Court on whether or not, I mean, basically, and Derrick, correct me if I'm wrong, basically it was the 14th Amendment on equal protection and due process claims, but whether or not a person, whether you're black or white or whatever color, has the right to buy or sell a piece of property to whoever they want. And the Supreme Court ultimately decided in that case that the state or the city cannot infringe on your right to buy or sell the property to whoever you want. And so they ended up striking down the city ordinance. Is that basically right there, Derrick?
That's basically right. Struck it down not on 14th Amendment grounds, but as you point out, impairment of contract. The city ordinance here just does it in fact infringes and inhibits upon a person's right to contract as they please, and without reaching the equal protection question that would come much later. And as we'll discuss in our second case, they made their ruling based on impairment of contract. But as you talked about, Steve, this case starts in, you mentioned 1910. That's the background of the case. And what an interesting historical arc, if you will, for the background of this case, how the case came into being and how it connects to our second case is incredible. We're here in 1910, about a decade and a half removed from Plessy versus Ferguson. And I want to emphasize that because it's easy for us to, for us to talk about it and for the listener to hear dates and years, 1917, 1948, and think about them as such a long time ago from 2021, but to place them in the context of being just a decade and a half removed from Plessy versus Ferguson gives the listener a different picture of what's actually going on. We've got Plessy in 1896 that says the Supreme Court says that the 14th Amendment equal protection clause permits laws from the state that maintain the custom of separate but equal. And so here we get a decade and a half from that conversation, from that ruling, and we have individuals, black and white, who are functioning and trying to figure out exactly what the landscape of the United States in general, and particularly the southern aspect of the United States, is going to look like with respect to race relations and living conditions in that regard, since the Supreme Court has now said separate but equal is a constitutional aspect. Now we've got people doing what they've always done. They educate themselves. They go about establishing businesses. They move from this place to that place, one locale to the next locale. A Supreme Court decision doesn't stop that. And so one of the things that happened in 1897, a man named by the name of George W.F. McMeechan, Black man, graduates from Yale Law School in 1897. His classmates named Walter Scott Miller. McMeechan practices in Connecticut for a little while, but later on moves to Baltimore, where along with his classmate Walter Scott Miller and a Howard Law graduate named William Ashby Hawkins, they set up a law practice, become tremendously successful, Yvonne. And as a result of the success that they have, McMeechan decides that he's going to purchase a home in an area called the Utah Place neighborhood. Now that abuts about a block away what was then called a white neighborhood. Well, Mr. McMeechan's success and Mr. McMeechan's purchase of the home in the Utah Place neighborhood seemingly upset another gentleman who coincidentally happened to be a lawyer whose name was Milton Daschle. And Milton did not graduate from law school. He read law. That was common at that moment. We all know you could become a member of the bar by doing what they call reading law. But even though he was successful at reading law, he obviously was not too successful at practicing law. He didn't enjoy any degree of financial benefits from it. And one law review article even says that he was characterized as a briefless lawyer. So he didn't have much in the way of any kind of cachet or prominence in his profession. But he lived about a block away from the home that Mr. McMeechan purchased. And somehow this must have raised something in him, Yvonne, when the Supreme Court just a decade and a half ago said that there can be separate but equal, but it just looked like to him that they were not on equal footing. And so he began to make it his personal mission to suggest to the city council of Baltimore that something should be done about this encroachment into our residences by Negro people. Well, he was successful, and ironically, the Solicitor General at the time of Baltimore was a gentleman named Edgar Allan Poe. Nope, not the poet, but his name nonetheless was Edgar Allan Poe.
Wow.
And the city ordinance did exactly what you mentioned, Steve. There were two previous versions of the ordinance that had some flaws to it. They went to court and they were struck down. But the final version of that ordinance did exactly what you mentioned. It forbade the sale of a particular home if that block was predominantly occupied in residences by whites. No Black person could be sold that home, and the reverse was true. If an area was predominantly resided in by Blacks, no white person could live in that home. Well, that law became that became law in Baltimore in 1911, 1913. There is a challenge to it. And ironically, George W. McMeechan is one of the lawyers who is challenging that provision that his own actions gave rise to. Took that to the Maryland Court of Appeals, but the Maryland Court of Appeals sustained and upheld the ordinance as a proper exercise of the city's police power. And so that began a round of municipal copycat, if you will. We have in 1912, Winston-Salem adopting the same ordinance, almost word for word, that Baltimore had. 1913, it happens in Asheville, North Carolina, Richmond, Norfolk, and Roanoke, Virginia, here in Atlanta, Greenville, South Carolina, Madisonville, Kentucky, and a year later, 1914, in Louisville, Birmingham, Alabama, and St. Louis, Missouri. It became known as the Baltimore idea, and it was pretty much functioned just like the exclusions that were written into state constitutions denying Black people the right to vote that began in Mississippi in 1890, when the states began to rewrite their constitutions to get around the 15th Amendment, saying you cannot abridge the right to vote based on race, but they began to attach preconditions dealing with and prerequisites around registrations, and state after state, starting with Mississippi, going into Alabama, to South Carolina, to Georgia, and on, began to change their constitutions. And so we've seen as early as 1890 with the right, with voting, as we're discussing with the restrictive covenant cases here, and even today, there continues to be among certain states sort of the copycat mentality. You have a pernicious law. We need to have a pernicious law.
Right.
What can you do? Punchinella, punch a shoe. We can do it too. It seems to be that the kind of thing that's going on. So by the time we get to Louisville, the Baltimore idea, of course, had spread there, and McMeechan and his partner, William Ashby Hawkins, actually file a brief in the Buchanan case on behalf of the NAACP. And so that tells you that long arc of how we got to the case, with the case of Buchanan versus Warley. And as we started this portion of the conversation, that's again, what the Supreme Court did was not address the matter from the equal protection aspect, but chose to do it from an impairment of contract, on an impairment of contract rationale.
Yeah, I at one of the articles that I read about this case, because this was not a case, if it was covered in law school, I forgot it. And I will say property was by far my worst subject. But anyway, if I learned it at any point, I forgot it. But that was one of the things that I thought was interesting in reading about this case, and commentary about the case was like, it's an important case, but don't think you're about to read an inspiring opinion, because you're not. And just talking about how everything was couched. I mean, it's genius, really, because it was all couched kind of from the perspective of the white property owner. Which I think if you don't know the background of the case, I think you could easily read this case and not even get how important it was, or appreciate the strategy behind why that was so smart to do it that way.
It's interesting you mentioned it, Yvonne, and that's why I wanted to, at the beginning, emphasize the context in which the case came.
Yeah.
And another aspect of that context is that when this case begins in 1913, the NAACP as an organization is barely 4 years old.
Wow.
It's not the NAACP as we have come to know it at right now. It's only been in existence since 1909, and it began its foray into the legal arenas around the issue of voting. But the lawyers that ultimately became attached to and part of the NAACP network had begun what we would call, and what I call, the first civil rights cases as early as 1885, dealing with the exclusion of Black people from juries. That was among the very first things that that Black lawyers who had graduated from law schools actually gravitated towards, because coming out of the Reconstruction era, you still had the prevalence of Black codes, vagrancy laws, that if a Black man didn't have employment, he could be summarily arrested just for not having employment. And then, of course, when he's placed on trial, he has no peers on the jury. And so when the Black lawyers came out of law school, these were among the very first cases that they were handling. And so these same lawyers, sitting in the meetings and the conversations and the discussions about the formation of the NAACP, found it interesting and intriguing to say an aspect of what we're doing here ought to include some kind of legal advocacy for which they had already begun. And to be able to say, as you mentioned, the genius of those practitioners forming these test cases. They themselves were part of the brain trust in engineering what the strategy should be. They thought correctly, I would imagine that it was just a few years ago that there was this coming from the Supreme Court that this was about separate but equal. So we'll test the equal aspect. We'll test it in terms of its fairness, its applicability, its efficiency, its efficacy, its force, its strength with that group of people who enjoyed the rights in the first place. If under your present jurisprudence you are diminishing the rights of whites, what good is what we're doing? So it was a stroke of genius to do that at that period. So and like you when you read that, you're not about to hear an inspiring tale, but you certainly are. When you read Buchanan, you certainly are catapulted to a time where you go, that is a stroke of brilliance in terms of a legal strategy, how to get in front of the court and get the attention of the court, and more importantly, get the court to agree with the position that you're taking.
Yeah, I noticed, so as you said, just to make sure our listeners understand the background. I mean, after the Civil War, you had Reconstruction that was started, where we actually made a lot of forward steps in more equal protection, more equal rights for African Americans. And then essentially after Abraham Lincoln is shot and Andrew Johnson takes over, he basically starts rolling back Reconstruction, and you have the black codes put in, like you were mentioning, Derrick, as well as the sort of deal that was made to get Rutherford B. Hayes elected president in order to, roll back the military that was down in the South. But during that time, so I mean, basically we're talking from, late around 1870 up through about 1910, I saw somewhere that there had been a total of basically 28, quote unquote, civil rights cases brought in that time period, and 22 of them had been lost. And then after this case, and it's not an inspiring case the way it's written, but it is a step, although maybe a baby step forward in civil rights. But it's after this case that then the tide starts to turn, and slowly that civil rights cases start becoming a lot more successful. And, up until we, basically go through Brown versus Board of Education, and then up through the 1964 Civil Rights Act. So it's sort of a tipping point or a turning point case that really, starts to change the momentum in the movement of civil rights.
It actually ought to be one of those cases that's raised in law school for the point that you made. What happens when there is virtually and perceptibly nothing on your side? Now, we've heard, if you have the facts on your side, you pound the facts. If you have the law on your side, you pound the law. If you have nothing on your side, you pound the table.
That's right.
Well, what do you do when there's no table to pound?
Right.
You've got no facts, you've got no law, you have no table. What do you do at that particular moment? And you talk about a case study in what the lawyering endeavor is all about. This is one of those. And I don't know where we put it. I don't know if we limit it over to into the constitutional aspect and the evolution of equal protection. I don't know if we put it in a skills discussion. I don't know if we put it in something as it relates to professionalism, but it is a case that should be part of the law school curriculum, if for no other reason, just to indicate this is the strength of the lawyering endeavor. It can take a look inside what's happening from a social and civic, political, economic, and personal standpoint, and craft an approach towards what we all know and believe should be the ultimate solution. But here's where the first step is, and let's take it. and it does have its place in being an inspiring case. It's just not the kind of case that's going to make you stand up and shout hallelujah, if you will, but it is one that's going to get your attention and go, wow, that one's in the scriptures too.
Yeah. Well, and I'm so glad you said that, Derrick, because I think that the genius way that that this case was framed, that the issues were framed, some of those ideas are things that you do as a practicing lawyer right now. As in terms of if you have a case with multiple plaintiffs or a potential class case, thinking about who your plaintiffs are going to be, thinking about how you frame the issues and what types of claims you bring in a complaint when you have multiple options, but there may be strategic reasons for not bringing them, or there may be reasons for appointing a guardian to represent somebody versus having them represented by a parent, things like that are not necessarily, that I think you kind of learn as you go, practicing wise, the importance of framing the issues, framing a case before it even gets started. And that's what's you're right. This case is inspiring once you know the backstory and you don't think of it as just a property dispute case that popped up organically.
Yeah, it also, to me, Derrick, really sort of, your group, the Arc of Justice Institute, is based on the famous quote that the arc of history is long, but it, bends towards justice. It's sort of like is a great example of that. I mean, we're, over this time period, we've been working, harder and harder to get more equal rights, more civil rights. And here we are 100 years later, where we're still working towards that, but we're still moving forward, but it all sort of starts there. But I think it teaches citizens, law students, and lawyers that every step is helpful and every step counts, even though you may not get an overwhelming victory right from the beginning. But each step counts in that progress.
Exactly.
Well, let's talk about the second case. So now we've moved to 1948, and this is a case called Shelley versus Kramer. And basically, this one takes place in St. Louis, Missouri, and there was sort of a companion case called McGee versus Sipes that was out of Michigan. And I think these are both basically on the same issue, that we are now out of the realm of city ordinances, but we are into private restrictive covenants that have been put in by neighborhoods. And so essentially what you have in this case is that Mr. Shelley had bought a piece of property in St. Louis in 1945 and didn't know that there was a restrictive covenant. And I don't want to read exactly the language that was in there, but it was a covenant that had been agreed to by, I think, 50 out of 57 property owners that basically prevented people of, and the quote is, of Negro or Mongolian race from occupying property. And so after Mr. Shelley purchases this piece of property, there is a person as part of this neighborhood who lives about 10 blocks away named Louis Kramer, who basically sues in order to prevent Mr. Shelley from moving in and gaining possession to this property because of a restrictive covenant that was in that had been put on the property. And so then the case goes up to the Supreme Court, along with the case of McGee versus Sipes, which Thurgood Marshall was involved in representing. I think the lawyer for Mr. Shelley was George Vaughn. And basically the holding in that case, which I thought was really interesting, was that the Supreme Court said that a private race-based restrictive covenant was not unconstitutional and didn't violate the 14th Amendment. But you couldn't ask the state to enforce that. Once you go to court to enforce it, then basically you're asking the state or having the state take an action that is a violation of equal protection and due process and does violate the 14th Amendment. And so basically they found for Mr. Shelley against Mr. Kramer and basically against these restrictive covenants, basically finding that while they're not going to stop you from having these restrictive covenants, there's no way you can enforce these through the state or the court system. Is that basically right, Derrick?
That's it. That is exactly right. And again, we've got some connection. We've got some background, Yvonne, how this happens and who's involved. And the central connection is this nexus of lawyers across the country who seemingly have some connection to this new organization called the NAACP. Now we get to Shelley versus Kramer, and the NAACP is now almost 30 years old, and it had begun to enjoy some success in creating chapters across the country, explaining to people that here are your rights. Here's an organization that will spend its every waking moment to defend and to advocate in courts. And as I mentioned before, there are lawyers all across the country who are becoming involved in the NAACP. Well, out in California, out in Los Angeles, one of those lawyers' name is Burton Cerruti. I just kind of like saying his name, Burton Cerruti.
Right, yeah.
It has such cachet to it, such strength to it. Just Edward Burton Cerruti. It sounds like somebody who should be having a nomination to the Supreme Court by somebody from that standpoint.
Right.
But Mr. Cerruti is a lawyer out in Los Angeles, and he graduates from Brooklyn Law School. And his first forays into advocating for people's rights is becoming vehemently and publicly opposed to the movie The Birth of a Nation. He wages nearly a campaign to dispel the stereotypes in that movie and to ensure that this movie is not going to be regarded as the definitive statement on African-American existence. Well, of course, you can very well imagine that he is a beloved figure by the Black community in Los Angeles at that time. And then he himself becomes one of the principal founders of the Los Angeles chapter of the NAACP, probably after having heard or met with or had somehow come into contact with W.E.B. Du Bois, who is at that point the preeminent national voice for the NAACP. And the conversation about the work that Du Bois is doing and the positions and philosophies that he have rank very high in the nation and in the Black community with respect to the philosophies and work that Booker T. Washington is doing. And so Mr. Cerruti, Burton Cerruti, is the face of what you would call civil rights matters in California, in Los Angeles, including the growing use of restrictive covenants in the municipalities. And the same thing out in California, they had certainly come to understand that the federal court, with a case like Buchanan, had struck those ordinances down on grounds of impairment of contract, and they began to be creative, and they began to use private contracts. Since the court has now said you cannot impair the right to contract through these ordinances, then we will use the contract to contain the restrictions that we want, as opposed to asking our legislative bodies to do so. Well, there's another gentleman named Loren Miller. And Loren Miller is an incredibly distinct figure in the annals of law. He comes out of law school, and he immediately has a reaction that law, it might be a waste of time. He and a few other of his contemporaries are disillusioned by what they thought was a failure to follow through on some of the progressive expectations and assurances that were supposed to be a part of the Woodrow Wilson administration. And he really becomes focused on issues of class, more so than issues of race. And he felt that law was sort of somewhat inefficient to address the root causes and many tentacles of class than his contemporaries, people like Charles Hamilton Houston and some of the other law graduates that he knew. They focused more on the law. Well, Mr. Cerruti passes in 1927. The work that Lauren Miller had begun to do with Mr. Cerruti and on his own in handling cases, particularly those cases that involve Black men involved in the criminal justice system, the inequities and unfairness there allowed Mr. Miller to gain a reputation there. And upon Mr. Cerruti's passing, the Black community in Los Angeles almost anointed Miller with the mantle of being the restrictive covenants lawyer. And that put him at a little bit of conflict because, as I mentioned earlier, he didn't think the law was the appropriate remedy. He didn't think it was the appropriate tool. He owned a newspaper coming out of law school, and he used that platform as more so than law. But now all of a sudden, here he is, and he's being asked to handle these restrictive covenant cases. But it was not too long after that he began to change his viewpoint, because as you alluded to, Yvonne, when we're sitting and we're thinking about strategizing and who to name as a plaintiff and what court to put it in, and just using everything in our panoply of how the law can improve conditions, he began to see it less theoretical and more practical. And then he began actually taking on restrictive covenant cases. And he, in fact, became Mr. Restrictive Covenants. He was eradicating the use of, he was fighting rather against the federal housing authorities' cognizance of restrictive covenants in contracts that were backed by the federal government. Mm-hmm. He did it in context of long before people became fascinated about how veterans were treated. When veterans were having problems finding homes out in Los Angeles, and keep in mind we're approaching the point in Los Angeles and California where World War II is about to break out, and so there's a great buildup of the military out in California. He is seeing how members of the armed forces are treated with respect to housing, and how that treatment is involved with restrictive covenants. And so he is really becoming a go-to person out in California for restrictive covenants. Well, so when Shelley versus Kramer comes along, who's the person to go to? It's Lauren Miller. And when you mentioned Thurgood Marshall, there was such a great respect for Lauren Miller. I came across something where they said, where it was written that the lawyers the members of the bar in Los Angeles and the surrounding areas had such admiration and held his work in such awe, they would postpone their cases to go hear him in court. I'm pretty sure their clients weren't too happy with that, but they would do it. They would do it nonetheless, just to hear him artfully articulate not just what the law was, but almost in pinpoint precision to explain how the application of a particular ordinance affected one individual client on Tuesdays and Thursdays, and everyone else was only affected on one day of the week. He was just that precise, that detail. So admired was he by that nexus of NAACP lawyers. He was among those final editors that Thurgood Marshall would submit briefs to on major cases. When Thurgood went to Lauren Miller as far as the Brown versus Board of Education brief is concerned, There's some letters that go back and forth between Lauren and Thurgood Marshall, and Lauren spares absolutely no punches whatsoever. At one particular point, we're focusing on a historical argument that that the briefs were making. He just wrote back, "This is weak and conciliatory." And he gave them advice as to how to change it from that standpoint. Lauren was one of those people that Thurgood would talk to first and last in terms of how to proceed. So it's no surprise, of course, that Lauren, in terms of making this a bigger case, he got a hold of Thurgood Marshall. And we end up with Shelley versus Kramer in the court. And there is a direct request from the court. Look at this on 14th Amendment equal protection grounds. Look at it from the standpoint of saying that the use of racial restrictive covenants in contracts is violative in and of itself of the 14th Amendment. Unlike what was done in Buchanan, here we want to actually look at it. Well, the court in Shelley did look at it and went through the historical aspects of that. The right to contract is one of those things that the framers held in high regard, and an odious provision of a contract may be just that, but it does not rise to the level of being violative of the 14th Amendment. It focused on what we call the plain meaning, the plain language. It involves state action here. It says that no state shall deprive a person of equal protection of the laws, and we don't have that in the contract itself. But in that fit of legal genius, the court agreed with one of the brief writers and said, but we do have state action in the form of judicial enforcement. And it talked about that long line of cases that it held that state action is found in the work, in the activities of the executive, the legislative, and the judicial branch. To seek the enforcement of the judiciary is, in effect, the court saying, seeking the blessings of the state. And so there's no way to separate that. If you bring these covenants before the court and you are asking the court to say, yes, we can and we will agree with the conditions of the covenant, then you are asking the court to you're asking the state to give its blessing. And therefore now the state, by virtue of the judicial branch, has now engaged in an action that deprives a person of their equal protection. And that judicial enforcement, rising to the level of state action, is what makes this a violation of that amendment. And so the restrictive covenant cases are, on that reason, unconstitutional.
Derrick, I wanted to ask you about something, and this goes back to, I thought if anybody knows, it's going to be Derrick. This goes back to when Steve was introing the case, but one of the things that stands out, just as you're reading about sort of the background of it, is what is this Mongolian thing about?
Right.
Was that like a historical, just, I mean, obviously we're already dealing with racism, but just like a racist, what is that? What is that about? Or did they have a separate concern about people from Mongolia?
I wish I had an easy answer, other than to simply say that there has always been in the annals of human history this impulse, if you will, or instinct, now I like the word impulse better, to classify people according to a particular characteristic, a particular phenotype that will justify placing one person in dominion over another person. Mm-hmm. So we have out in California a large contingency of what we would refer to as at that moment, referred to the Orient, the Asian population, Chinese population, stemming from the period in history when we exploited Chinese labor to create the vast railroad system. Mm-hmm. And so now, of course, human beings have a tendency to find a way to get along with each other irrespective of their ethnicities and backgrounds. So you might just happen to, it might come as a surprise to people who believe in terms of purity and things of that nature, but you just might actually happen, it might happen one day that a person of quote unquote Negro descent and Mongolian descent might sit down and have a conversation with each other and say, hey, would you like to go to a movie? And the next thing you know, people end up intermarrying and things of that particular nature. So as a way to maintain this purity, as a way to maintain this sense of what should properly be characterized as America and as an American, then we're going to make certain that we come up with definitions and explanations of who does not fit in the desired example and exclude them. So that's the explanation, Yvonne, as to why you're choosing in your statute to include these two groups of people. And you're not, it makes no sense except in the context of as I mentioned, this is what we do when human beings come into contact with each other. I have named this the dominion impulse disorder. I've been thinking about this since we come out of the issues surrounding everything under the heading of Black Lives Matter. And we've, as a nation, we've finally gotten to the point where everybody can say white supremacy without trembling. But I've been thinking that probably is just a branch on the tree. And it's not the root aspect of it. We go back in history, we've always seen that when human beings come into interaction with one another, sadly, there is always this thought that one has to be in domination over the other. Men have to be in domination over women. One race has to exercise dominion over the other, the rich over the poor, the educated over the uneducated, this religion over that one, Georgia over Georgia Tech, Michigan over Ohio State. There's always got to be in interaction within human beings, this dominion impulse disorder. And that's, to me, that's the root of everything. How do we remove that impulse in our interactions with one another? And you fast forward throughout history, and by the time you get to the restrictive covenants, we've just decided in that particular moment, because of the demographics that are happening out here on the West Coast, because of what's going on, we're going to exclude, we are going to characterize. Another part of my favorite language is we start the Constitution with "we the people," and 120 some odd words later, we include the constitutionally incompatible and incongruous phrase, "all other persons."
Right.
To talk about a great trial, is the longest running trial in history. We the people versus all other persons. And what we've been doing is figuring out how many different groups of people can be other. How can we otherize this person at this time? So at that moment, the group that could be easily otherized because of how the history of it associated with how those populations came to be in the state at that particular moment, we will express that otherizing sentiment in our covenants along the lines of being Negro or Mongoloid. Long-winded answer.
No.
Sorry.
I mean, because it's important. And I mean, when I read it, that's what I was wondering, like, is this just a completely, inaccurate term used referencing, Asian people, or, it just seemed so odd. But I think your answer, it was better than the question, and that it kind of explains where this mentality is coming from and what it was trying to accomplish. But I it is a reading this decision, and I was so glad that you linked these two up for us, Derrick. But it is, you know, it is refreshing. I feel like, especially when you compare it to Buchanan, that the issue feels at least more that it's addressed head on. You know, like I wonder, like when it comes to Buchanan, like how, you know, if those lawyers, as long as they had, you know, an outcome that was a win, if it still felt like a win, if it wasn't addressing, you know, the sort of the equal protection issues, or what we would think of what was morally wrong about it.
I remember studying the equal protection clause in law school. I remember when we got to the portion of discussing the constitutionality of the Civil Rights Act of 1964. I remember my disgust at knowing that the jurisprudence and rationale of upholding the Civil Rights Act and the legislative rationale for it was based on commerce.
Mm-hmm.
Yeah.
I was disgusted that there was no way to just say in Congress and then have that affirmed in court that just says it's just about people.
Mm-hmm.
At the same time, studying the law, I became intellectually fascinated with the abject brilliance of the argument of focusing on commerce.
Right.
I thought, what a wonderful thing to do.
Right.
And then, of course, when you take that back and you go, I for some reason I cannot help but see the historical arcs, if you will, how everything connects and how everything is, in the words of the author James Redfield, the longer now. Now is a much longer period than the 24 hours we think it is, or this year 2021 now is a much longer period. And so when you go back to the 16th century and you take a look at how, this is my view, that this is the portal into which most of our present situations, that it's where they have their roots. And when you begin to see the emergence of globalization in the 16th century, the focus on precious metals as a way to combat the global dominance of the spice trade, and tucked inside the emphasis on precious metals, in order to extract them from the ground and carry them from one place to the other, you need horses and labor. And we made horses part of the global trade, and we made slaves part of the global trade. We made people commodities.
Mm-hmm.
And so the evolution of commoditizing people went from the 16th to the 17th to the 18th century, on to the founding of the United States of America, embedded into the colonies of the United States of America, having the attitudes, perceptions, presumptions, and preferences sneak their way into the Constitution, having those same attitudes finding their way into our jurisprudence. And then we get to the 1960s and we're having a conversation that says, well, you know what? From a public accommodation standpoint, if these attitudes touch commerce, then Congress has a right to say you can't feel that way, you can't behave that way, your attitudes are going to have to be adjusted because it's touching commerce. And so then when I look back at it and go, it had to be solved where it started, in commerce. There was a commercial attitude that commoditized people. We might have to have a commercial re-attitude to decommoditize people.
Mhm.
And so I have this range of emotions, Steve: disgust, intellectual fascination, historical revelation. And it's going, okay, so now what do we do with all of this? Because at the beginning and the end of the day, it is still just about people.
Yeah, it's interesting in reading the Shelley versus Kramer case. I mean, that's one thing that I was struck by, is that, I get what the Supreme Court is saying at that point, that the ability to contract with each other is something that we take, is very important. But I mean, at the end of the day, wrong is wrong, and putting these racist covenants in is just wrong. But they had to sort of, I guess in an intellectual way for them, say, well, we're not going to get in the way of you contracting the way you want to, even if you're contracting something that is just morally and morally wrong. But we are going to say that the state's not going to get involved in that. But you kind of wish why didn't they just say restricted covenants are just wrong? But I mean, from a constitutional standpoint, it's exactly what you just said. On the one hand, I'm kind of disgusted that they didn't just say it. And on the other hand, it's intellectually interesting that they, found their way to make it illegal anyways, but that they had to sort of do it in this roundabout way.
Mm-hmm. Even as we study the cases now, even as I put things together as far as the podcast is concerned, even as I'm reevaluating and retooling the Arc of Justice Institute, the Arc of Justice Project in this present / post-pandemic world, how do we navigate who we are with these newfound things? I still grapple with that dual reaction to things: disgust and intrigue.
Yeah.
And it causes a bit of consternation at any given moment. As you point out, Steve, sometimes you just want to say right is right and wrong is wrong. And it doesn't really take 475 paragraphs in a judicial opinion to say you can't do that.
Right.
And we have examples of that. That case that I mentioned that Mr. McMeechan worked on back in Baltimore, State versus Gurry, sort of alluded to it. But there was another instance in California when Lauren Miller was actually taking on one of the restricted covenant cases involving the actress Hattie McDaniel. She had purchased some property out in California, and it was subject to a restricted covenant case. And parties went before the judge, and they offered their arguments, and the judge wanted to see the property. Well, he went to see the property, and when he came back to the courtroom, paraphrasing, he said, "It's just high time that Black citizens be given the rights they were accorded under the 14th Amendment." Case dismissed. It wasn't 700 pages. It wasn't a 455 paragraph opinion. It was just about 17 words. Yeah. It's just, and basically he just said what you said, Steve. Right is right, wrong is wrong, and this is just ridiculous. Get out of my courtroom. I'm ready to go home already. Okay.
Right.
If I got to fight. If I got to sit in traffic, it's not going to be because of this. right.
So, but I'm sorry. Go ahead.
No, go ahead, Yvonne.
No, I just was going to say, and the flip side, when I was thinking when you were talking about it is, well, it's something that I hope everyone can agree now. That, it's very clear what was right and what was wrong. But I guess the flip side of, when it's crammed into this framework of commerce or whatever, that, okay, well, maybe that is more comforting or can be more comforting than it being left in as a value judgment when you're not sure how, if somebody's going to be right, according to what you think is right. The idea that, okay, that it's very sort of, it can feel very unsatisfying and unjust. And to think of it as like, plugging the Commerce Clause stuff into the computer and whatever comes out. But at the same time, maybe that's more comforting than just leaving it in the hands of of somebody, a judge that might be, bigoted or prejudiced or whatever, and just asking them to decide what's right or what's wrong.
Yeah. I wish I had the magic amulet to solve that.
Yeah.
Yeah.
But I don't.
Yeah.
But one thing, as we're discussing, I can no longer avoid making the statement that the course that we have charted for ourselves, by constantly ignoring what is right and what is wrong,
Mm-hmm.
because of our apprehensions of it, just keeps us going around in what I call just an evolving door. I don't know what religion you would have to have. I don't know what law school you would have to attend. I don't know what judicial philosophy you would have to have for everybody to agree to the following statement. If we've already decided that in the field of commerce that headphones are a good thing for someone to have if they're doing a podcast, and if we've decided that these headphones are a good thing and they need to be made by somebody, and if we're going to pay $17.50 an hour for the people to make the headphones, I just think it doesn't matter if you are a male or a female making the headphones, that one of them needs to make $17.50 and the other one makes $15.25.
Yeah.
I just don't think it matters all the philosophies that we come up with and the ideologies that we hide behind.
Mm-hmm.
And I want to emphasize that that we hide behind, just to recognize that we've already said headphones make sense. We've already said that we would pay $17.50 an hour. If a person walks over and happens to be female and can make headphones, why are we paying $15.22 an hour? It just doesn't, it's wrong.
Yeah.
And we just simply have to say that
Mm-hmm.
and be done with that, and be like the judge in the case that dealt with Lorraine Hansberry. I don't want to sit in traffic because we're having a legislative debate about whether Yvonne could make $17.50. You guys know that doesn't make any sense.
Yeah.
Mm-hmm.
She can make headphones. We value headphones. We've set this price. They get paid $17.50. And why do we need a philosophy around that?
Yeah.
Why do we have to come up with explanations for that? We could borrow from that particular judge who had the benefit of adjudicating that case with history in hindsight. Maybe if that had been a case of first impression for him, he might have said, well, tell me a little bit more about why it's problematic to live next to people of color. But because he had the benefit of and the weight of history behind him, he could just simply say, it's about time. This is crazy.
Yeah.
And so, Yvonne, we have something like he did. We have the benefit of history behind us. We are outfitted with sufficient and credible testimony in the form of history that tells us we have charted a course that makes absolutely no sense, and it is not sustainable.
Mm-hmm.
That's the reason we're experiencing all these weird movements and everything at this particular moment.
Mm-hmm.
Everybody has their own movement, and they have it with names that just, in my opinion, are just masks for what's really going of something else that's going on. Just the pain of associated with having to assert legitimacy based on something other than just what's right and what's wrong. All because we are afraid of saying that, because we can't figure out, well, who's the arbiter of rightness and wrong?
Yeah. I think it's interesting just to kind of let the audience recognize like where the country was at the time that Shelley versus Kramer, again, we're in 1948, that during that case, 3 of the justices had to recuse themselves because they lived in neighborhoods that had restrictive covenants on them. So, you're talking on a 9-person court, 3 of them are recusing themselves because they live in the same type of neighborhoods that are being litigated over. So this was obviously a very common practice and was widespread among across the country.
That was Who made the motion? Did they do it themselves?
Right. Yeah, exactly. That's right.
Somebody,
That's right.
somebody bring it to their attention.
Yeah.
Mr. Justice Story, I think you probably need to recuse yourself because
Right. Exactly.
Yeah.
That's
I did not know that was in my deed. Who knew? What am I supposed to do?
Yeah. Ugh. Don't ask me. Did I mention how bad I was at property law?
Right. Yeah, that's right. Derrick, let me just thank you. This has been just a great, as always, just a great discussion about history, about the civil rights era, and then about where this country's been and where we're going, and how we got there through some of our great legal cases. Let me remind everybody, we've been talking about the Buchanan versus Worley case, which was in 1917. It's a Supreme Court decision you can look up. And Shelley versus Kramer, which is also a Supreme Court decision in 1948. And we have been talking with Derrick Alexander Pope, the president and founder of the Arc of Justice Institute. And you can look him up at onthearc.net. You can also listen to him, and you'll hear a cameo from Yvonne on the Hidden Legal Figures podcast. So please go check out the website onthearc.net, or listen or do both. Go to Hidden Legal Figures podcast. Derrick, thank you so much for your time.
Thank you, Steve. Thank you, Yvonne. Always a pleasure to be here.